I've just started now, but yeah, definitely I have to. It's okay for the council. It's okay for the council. I don't get enough for the council. I love it. Expect.
Akwasaganya ekibiina ekiggaya gavumenti omu ku bakulembeze tubulireko bikibyo ebimu ku byosooka leero kwatwalabye dokita olunaku lw'eggulo ng'agattiddwako omusirikale wa UPDF nga bagaa nti naye y'omu ku be baakola emisango gino egy'okukwata ekissi mu ggwanga ly'e Kenya. What is your take about that?
Of course kya buswavu kye bali mugezaako okukola okirabira ddala nti bagezaako okufuna engeri gye bagatika gino emisango kubanga Dr. Rose ekisooka bamukwatira outside the jurisdiction of this court, bamuwamba buwambi ne bamujja mu ggwanga lya Kenya ne bamuleeta mu Uganda ne bamuteekawo emisango egyali giraga nti bagamba nti meeting zatula simanyi Switzerland, Kenya wa kooti eno terina buyinza kukozesa emisango egikoleddwa wabweru w'eggwanga. N'ensonga endala of course gye tuwakanya nnyo ya kukozesa bacivilian mu kooti z'amagye. Kooti etaputa ssemateeka yavaayo olwedde n'ekyogerako bulungi nti bacivilian tebalina kukozesebwa mu kooti z'amagye. Kakati kino kye bakoze kye baakola ne ku bawagizi baffe ba NUP kimanyi bulungi babawamba bano ba Olivia Lutaya ne baleeta wano ne bakola ki bamala emyaka 2 mu kooti eno nga omusango gwe baali babataddeko gwakusangibwa n'emmundu. Emyaka 2 bwe gyayita ne babaleetera omusango gwa artificial guno gwe bataddeko kye gwe bagezaako muteekako nabo ne babagatako ogw'omusango. Bano si bannamagye. Bw'osoma etteeka lya UPDF Act ogw'omusango gw'abantu ab'amagye. So kakati bano si bannamagye ne bamwongerako ogw'omusango gwa artificial. So byonna tubiwakanya nga bw'omanyi naye nga bwe kugambye kati olaba baagala kukyusa charge sheet. First of all bongeddeko omusirikale ekirala ne bongerako nti meetings ezimu zaatula Kampala. Olw'obuswavu kati bagezaako okulaba tukitereeza tutya kino kye twakola. Bakimanyi buli tebalina jurisdiction oba tebalina buyinza kukozesa abantu ku misango gye bagamba nti bakolera bweru w'eggwanga. Bakimanyi nti tebasobola kukozesa civilians. Kyova olaba bagenze ne bajjayo omusirikale yonna yonna gye bamugye ne bamugata ku fayiro eno. So tukiwakanya era ffe demand yaffe nga bolaba ebadde one bateebwe bano abantu kubanga emisango gye basooka bateekawo clearly gyali tegiri within the jurisdiction even of any court in Uganda by the way. Sina kooti y'amagye yokka naye muntu bw'asangibwa n'emmundu mu ggwanga lya Kenya ekyo kiba kitya obuvunaanyizibwa bwa kooti za Uganda. Yali badde akozesebwa Kenya kubanga Kenya nabo balina amateeka baali badde bamubuuza kale assuming nti emmundu yagirina baali badde bamubuuza emmundu eno wagifuna otya olina license yayo n'awozesebwa mu kooti za Kenya so si mu kooti za Uganda. Naye kyenkugambye nti eno pattern tugirabye abawagizi ba NUP abadde mu kooti z'amagye bwe batu bwe badde babayisa baleeta ne bagatako emisango emirala ne bakola ki naye ffe tuwakanya eno kooti eno n'okugiyita kooti obeera giwadde amaanyi mangi nnyo oba ogiwadde ekitiibwa kingi kubanga eno yali badde tribunal nga bwolaba disciplinary committee ey'amagye okukwasisa empisa magye naye basiviliani tebalina olunaku n'olumu kye bakola wano. Okiraba nti abo abantu abatuula mu kooti eyo chairman waayo n'abalala si bannamateeka naye nga waliwo emisango ejyanagomala wano oyo judge advocate abeerawo just ku advisinga ate naye emisango egiri serious bwe gityo tosobola gamba nti abantu balete mu kooti bweti twegamba muzungu tuteranyo gamba nti nokote prosecuting abantu wabula persecutinga abantu kubanga ekisooka General Museveni kati ye muwaabi ye complainant mu luzungu ye prosecutor ye muwolereza wa gavumenti ye mulamuzi kubanga bonna bonna abenjogerako yaba appointinga ekitegeera kakati bwobanga gwe judge gwe complainant gwe prosecutor oba osuubira bwenkanya ki batambulira kukoda
ogereko ne ku nsonga ya Aaron Kiza naye okukwatibwa wano mu kooti namulama
of course ekya Aaron Kiza kyali kikyamu nnyo. First of all olaba ekibonero kye bamuwa bamugaba emyezi 9 kimenya amateeka kubanga kati contempt of court osobola otya okusiba omuntu obangerere nalyonna naye n'ekirala walaba Aaron Kiza nti yali abataddeko akakiso nga buli lwajja wano abakootingira amateeka constitution n'ebirala kati ne bagezaako okutiisatiisa bannamateeka ne basala wali olaba nti kyonna baali bakipulaninze n'okumugaana ogenda kutuula wali balooya balala bwe baali kyali kipulaninze nga banoonya omuwaatwa bagenda oyitamu okumukaba bamutwale mu nkomyo asigale eyo. So ebyo byonna byonna biviolatinga constitution, violating amateeka n'ensi yaffe.
twalabye ebyatambudde mu mpaka tutangaalizeeko
lwaki tetufokasinga ku musango guno?
Okay, briefly in English ku byotugambye.
Yeah, so we condemn the continued detention and trial of Dr. Besigye and Ajibet Kamlegeya in the military court. The military courts have no jurisdiction to try civilians. So the Constitutional Court has been very clear on that point, that these courts are put in place to deal with disciplinary offences relating to the military, what they call service offences. They don't have any jurisdiction to try civilians, which the Besigye is and the other people. Of course, by amending the charges to add a soldier, they are trying, now they are ashamed, they are trying to figure out how do we bring them within the jurisdiction of the court. I'm trying to say that some of the meetings start in Kampala. Because as we have been saying, if people are found with a gun in Kenya, the courts in Uganda have no authority whatsoever to try that offense. Because there are courts in Kenya, they should have handled that matter there. If he had committed any offenses in this country, they should be tried in civilian courts, certainly not in military courts. So we condemn that in the strongest terms possible. And of course, we have been very, very categorical that Dr. Besigye should be released and his co-accused. If he committed any offense in Uganda, he should be tried by civilian courts. The reason why General Museveni loves using these military courts is because he is the prosecutor, he is the judge, he is the complainant in most of these political cases. He knows that he has full control over them. He appoints the judge advocate, he appoints the chairman of the court, he appoints the prosecutor, all these people are under him. So if all these people are serving the interests of General Museveni, then how can there be justice in such a matter? And yet you see they are trying to add grave offences. This, what they have just done, happened to NUP supporters. Because when our supporters came here, they initially were charged with unlawful possession of ammunition and all that. After 2 years in detention, they amended the charge sheet to add treachery, which is a very, very serious offense, which is akin to treason. So they added that to, so you can see that this is just not prosecution, but persecution of the opposition, persecution of those who are opposed to the Museveni regime.
And then Council Aaron?
Yeah, for Council Aaron, we condemn the manner in which he was violently arrested and, of course, given a very, very harsh sentence, which is unlawful. You saw that it was clearly choreographed because Aaron Kiza has been very, very categorical about this court, saying it's not even a court, it should be a tribunal, talking about the law, the right to representation and all these things. So I think they were trying to find a way of dealing with him. After several times trying to suppress him and he was not, budging, they decided to use this very court to send him in detention, which is unfortunate. You can imagine where you have lawyers coming to represent you, and they end up also being taken to court, to jail. So it's very, very unfortunate. And we join all those who are demanding for the unconditional release of Advocate Aaron Chiza, because what happened to him was the epitome of injustice and impunity.
Thank you so much. So that have been counsel, the Secretary General of National Interplatform. Shall be giving you everything, every update. And whatever is happening here. Subscribe, like, comment, and share. Yes, Peter Moses, Wagwan, good morning to you. Thank you for keeping it Extreme Media Yugi. Yeah, we have started. Tell a friend, share the link, share the link. Share the link in all your groups that we are almost starting. Yeah, share the link, share the link, share the link. Tell your friends that we are starting. We are almost. Ariho Joseph, thank you. We shall be giving you whatever is happening here. The security is tight. Security is tight this side. Security very tight muko birala muko era okuyingira wano olina okuba nga oyise makubo amatuufu. Let me share the link today. Yeah, I hope it will be consistent. Yeah man, liking a video, jukira wapoji wadeka like, eba eduka omusinge nga gwayindi, subscribing, liking atera community nga twatuseewo dda ku military court, twatuseewo dda what he doing Lewis Baku. No, this is a political issue, you understand? This is a political issue. Good morning, Casper. Mukasa Law is live here in Kiru Oda. Yeah man. Oli ku Extreme Media Yugi mwebale nnyo kubanga mukola omulimu gw'amaanyi nnyo. Subscribing, liking, atera commenting. Secretary General ye already yatuuseewo dda. Secretary General w'ekibiina kya National Unity Platform oba leero luno lugenda kubeera lutya? Amazima tetumanyi ekigenda kubeera naye nga amazima wo gali nti olunaku olwaleero eriyo chances nyingi okuba nti abakulu bano bayimbulwa, yadde emisango babalingiddeko emisango naye emisango bagigaanye. Agambye emisango egyo nedda tetugenda gikkiriza. So all you need to do is subscribe, like, comment and share the link to all your friends. Sharing mu groups zonna wagambe nti Extreme Media twatandise dda, teriyo walala. Teri walala, oli ku Extreme Media Yugi fe abatuuseeyo eno tetuukika eno biralamuko. So this is Musime Trevor. It's a political issue, but at the moment he has come, they are not going to release them. Ate bw'otyo bw'ogambye kale mukama wange bw'oyo eyo ndowooza ye ng'omuntu bw'atyo bw'alowooza. But all you need to do is subscribe, like, comment and share the link. Tufunewo bakansi wano abalala tulabe nga tukwasaganya ekintu kino kola.
Now, when a soldier commits an offense, a service offense, even when in that country, then the Ugandan law, the Ugandan territorial jurisdiction, has powers to try such a person, because a base in Mogadishu can be considered as a base within Uganda. You are a soldier in Uganda, so you're just an attaché there, but not the entire territorial jurisdiction. So we believe that the court does not have that jurisdiction to try anyone for any offense committed out of the country, except with those few exceptions which should be modified within the act and not any other offense. So those were the arguments we raised, and the state responded to our arguments and indicated that even if there was no extradition, that they have an MOU with Kenya, which we believe totally violates the laws, with international laws, because you cannot claim that you have an MOU that allows you to just pick someone from wherever they are and bring them and charge them here. And also there was no proof that that MOU actually exists. We believe that the state in trying to refute our argument that the bringing of Dr. Kizza Besigye and Ajabedi Lutale into the country was a violation of international human law, then they should have tabled such a memorandum before court to confirm that indeed what they did was legal. However, they didn't have that, and they were instead telling us to prove that the government of Uganda doesn't have an MOU with the government of Kenya on how they should deal with cross-border crime. And we also believe that what they are being charged of is not cross-border crime. Cross-border crime is definite, it's defined. Things like terrorism, things like money laundering, those are cross-border crimes because they may not necessarily be committed within the jurisdiction of one country. But a crime of having a pistol, a crime of having ammunition, that cannot be cross-border. Because in other words, if I'm a resident of Kenya and I'm a citizen of Uganda, if I have a license to carry my gun in Kenya, then Uganda cannot make it an offense in Uganda. So it doesn't come to the definition of what we call a trans-border crime. So today we are waiting for the ruling on those objections that we raised. We believe the chairperson could not make a decision at that point because of one, the extreme legal arguments we had, and as we all know that the chairperson is not a lawyer or someone qualified to be a judge, so probably need to consult with the judge advocate so they can come up with a ruling. So today morning we expect to have a ruling from the General Court Martial on the objections we raised, and we hope that the objections can be sustained and the accused person discharged from this court.
Any updates from Council Aaron Kizza? Because we saw yesterday it was all about Colonel Kizza Besigye, and you raised some issues about Council Aaron, and they said he's sentenced and you know what to do.
Yeah, see, once the sentence has been handed down, there are other various mechanisms that you can use to deal with a particular sentence, and I can confirm with authority that a legal team is handling that issue. We have several legal teams which are handling that issue, headed by some of the senior legal practitioners in this country. Some documents were filed yesterday here at the General Court Martial, trying to appeal that particular sentence because one, we believe it was extended illegally, out of context, because we all know that an advocate who is charged with contempt, the maximum penalty they can be given is 30 days. So then there are other mechanisms that we are using. Applications have been drafted and they are ready, and we're hoping the same can be signed by him today, and then we can have them filed in the other courts by tomorrow morning.
Briefly, Uganda Council.
Olunaku lwajjo ekyabaddewo kooti oba omwami wa gavumenti yagezaako okukyusa mu mpaaba ye kyetuyita amended charge sheet, nga kwekyo bagasseko omusango omulala oba n'ekirala ne bagattako omuwawaabiri omulala munamagye ali ku rank eya captain, bamuyita Ola Dennis. Naye amateeka gafuga kooti eno gagamba businga omuwaabirwa yenna alina kyatakkiriziganya nakyo naddala ku jurisdiction waddembe obutaddamu ansa ku musango ogumusomeddwa, either gukkiriza oba ogwegaana, era nga kooti emukkiriza okusooka okuteekayo okwemulugunya kwe ku kyetuyita objection to jurisdiction. Twakireese jjo, naye omuntu awabulaga kooti eno gwe tuyita judge advocate yagezezaako nnyo okwebalama okugoberera etteeka eryo, era twagenza okukkakkana nga kooti nga yeekasseeko yennyini n'asobola okukigoberera, era nakkiriza netuteekayo okusaba kwaffe muno emisango gino gimunaanyizibwa gyaddizibwa bweru wa Uganda, ate gavumenti ya Uganda teyina lukusa lutwaye nga omuntu yenna ku misango egibagyirizibwa bweru w'eggwanga. Omwami wa gavumenti yazzeemu mu kusaba kwaffe n'agamba buno balina ekiwandiiko kyetuyita MOU wakati waabwe ne gavumenti y'e Kenya, naye tebasobodde kitulaga oba okiwa kooti. Era olunaku lwayo tusuubira kooti egenda okuwa ensala yaayo ku objections twaraisinze oba ekyasobola okuwuliza omusango guno oba nedda.
All right, thank you so much, guys.
You are the first Kenyan president. Just one here. That's my first boy.
We are live. We are live.
First Kenyan president. Oh yes.
So guys, senior council atuuseewo, senior ayingidde Kalwa, nyirimu ayingiddemu.
Good morning, Council.
Guys, njakuba tufuna abantu ab'enjawulo. Subscribe naye nga twogerera ekintu ekiyinza okuba nga kisaamu kizira mubagambe sawa yona twanditandika kyeyalina yipiko muli batono. Omulamuzi mulyo senior ayingiriyo kinabeeraleero naye nga komenti atuuka senior kulembeddemu babulanzibulira Extreme Media UD. You're watching Extreme Media UD. Subscribe if it's your first time here. So it's what I tell you to always subscribe. Always subscribe. Mubanga ofunye notification yonna. Oli ku Extreme Media UD. Embeera bweti eri wano Court Martial wanowa emakinde tuli makinde era gwe olina okola subscribinga, likinga ate era commenting. Jogeza Nicola Eke is my mom. Era nga lunaku olwaleero already omukulu Besigye ne munne bamaze okuba nga batuuka era nga bwolaba kooti wali ali waggulu, abantu bali waggulu bayingidde dda munda era tujja kuba tutandika okuwulira omusango anytime from now. All you need to do is to subscribe, likinga ate era commenting. Ekintu kitambuze mpola. Yeah, mama. You're watching Extreme Media UD. Twakeddewo ne makindi effetwa. Remember, nyongera okujukiza nti ffe wano we didn't specialize nti watukola politics yekka, watukola entertainment no. Tukuweereza buli kimu. Tukola entertainment, politics. Byonna buli kintu kiba kikola amawulire, byonna tubikola. Byonna tubikola wano ku Extreme Media UD. So all you need to do is subscribe, like, comment and share the link. Tunakuwa tufunako abantu different people nga tuba tukwasaganya ekintu kino mpola.
For some time, not for a short time, but for a very long time, because the charge sheet was amended. A serving UPDF officer, Captain Dennis Ola, was added on the charge sheet. And for me, specifically, what triggered my mind is that the new charge sheet includes Kampala metropolitan area. Initially, they were saying they committed these offenses in Greece, in Switzerland and in Nairobi. And our argument as supporters and also the argument of our legal team was that this court does not have jurisdiction to try them. Now they have added Kampala Metropolitan. That means they are going to say Machinde Court Martial is in Kampala and therefore they can try these people. So I do not have any hopes, but like Besigye has always encouraged us, we are fighters, and under dictatorship, whatever Besigye is being subjected to is expected. Whatever Aaron has been subjected to is expected. But I've told people, we are fighters. I know this time round, we have received some blows, but trust me, we are going to fight back. We are not going to simply watch as Besigye stays in prison. We are not going to simply watch as Aaron stays in prison, because it's not about them, this is about us. When Aaron came here, he did not know that as an advocate, he was going to be put in the dock, he was going to be tortured and remanded. So this is equally for us to fight for the legal team. This is equally for us to fight for any other person that might fall a victim to the wrath that we are being shown at the court martial.
Thank you very much, Deputy Lord Mayor. It's not so good.
Well, sirina kyamaanyi nnyo kye nsuubira okuva mu eno kooti, kubanga ebyabaddewo oba ebizze nga bibeerawo mu kooti mwena mubadde mubiraba bulungi. Jo twabadde very surprised bwafulumiza charge sheet nga bongeddeko kati omunamagye gwe bayita Captain Dennis Ola. Nsuubira ne Dr. Besigye ne Obed ono omusajja tebamulabangako. Tubadde tuzze nga twemulugunya nga tugamba ebikolobero bino byeboogerako babikomitinga e Greece ne batugamba e Nairobi ate ne batugamba ne Switzerland. Naye jo bayongeddeko omusango omupya ate ne batugamba gwali committed mu Kampala Metropolitan. Kitegeeza kati eno kooti enoonya legitimacy etugamba nabo balina obuyinza obusobola okutrayinga Dr. Besigye. So ffe tetujja kugwamu mwanyi era tugenda sigala nga tulwanira eddembe lya Besigye, tugenda sigala nga tulwanira eddembe lya Aaron Kiiza, kubanga tukimanyi leero batutaawo naye naffe bagenda tukiba.
Tweyanza banange tugenda kuba tuyingira munda obedde era nga kulaba ebintu wano eno tugenda kuba tuyingira tukitegedde ekintu ekyo tugenda kuba tuyingira munda kati saawa yakuwulira musango. Kati saawa yakuyingira munda naye bwoba it's your first time yet, subscribe, likinga ate era commentinga.
I have to go when it is clear and I can walk straight, because it's so awkward standing here like that with the high shoes. You can even fall.
Tuli kuyingira munda nga bali mu kukola check up.
No more fighting.
That's true. And I can look at the corner. But when the direction,
Juli chanya omleseyo. Chana gwe wedaga mu bichayi.
Tasumulula? Anti obumu gukute kamera afande. This time round sound simanyi obajja kuba state fani tekeko wano kanteke wano eno fani ndereko wano
Ayo bana. Okola we bale.
Buno okola. Guys tuyingidde munda. Asagala kubuukawo. Guys tuli munda kati. Okubanga buwulirwa. Naye nga sharinga video sharinga. Eta sound tujjagezako leero okikwasaganya. Ebitiibwa musharinge. Naye nga kansolo Lubongoya naye buli yakansadda waali ndowooza oba omulaba kansolo Lubongoya imirira kansolo Lubongoya kasini akatule oyo yatudde dda likinga tera omwana kansolo Lubongoya yatuse dda sharinga ya tuba tutandise Buyende Alex Mpagi kale ebale nnyo kubanga ngoberera mukulu okuva Buyende Alex naye obaganyeewo ndi mukuga olowooza lwaki nze siri awo nandibadde awo ate kati zojja kuba onzibikiriza lowooza nze lwaki siriiwe kale beerawo
byonna biteekeko bireko bibiri ayeyita omusajja ajjangaano
zonatiddewo natulawo ogenda asoma biri sagala otuule this time round
ajjangaano ino kooti y'amagye tata wange w'amagye
Alright, my people, tuba tutandise afunye enfo
si mwana wa
sharinga utambule wano mpola mpola tuyingidde munda obedde ebintu bijja kuba bitandika omulungi ali kutugoberera
ani agenda okunkolirako leero ojudde akoze atya
Munange aliko what do you think kigenda okubeerawo comment section what do you think oli kulaba extreme media udi nga tugenda kuba tutandika esaawa yonna tugenda kuba tutandika likinga meetinga what do you think olunaku olwaleero kyekirowooza what do you think will be here but watching the next media sharing you share the link share today if you haven't yet subscribed kindly subscribe if it's your first time here and when you subscribe make sure you click the notification bell so that you'll be updated.
No, let him stand on the other side. Because he's tall. He's tall, yes. Yes. I'm blocking you, eh? Wait, stand on the other side so that the other people about it. You see? No, I'm not saying that's what I'm saying. Stand is a good thing. The advantage is that you are taller than the rest.
Ask it. Baba's Ruth.
No, it's not a matter.
Baba's Ruth, thank you so much for keeping it. Dr. Morgan, thank you so much for keeping it. Thanks to media you.
I did not take a decision in me being born like this.
Ensonga ya tolo gyakulembeza.
Gyakulembeza.
Tujja kwatandika sharinga tujja kwatandika wanezekalensi kankafu
oli omusirikale
Lenzo olugogo.
naye nga tolina omanya secretary general owa kibiina kya national unity platform obedde yeewaali yatuusedda nga bwomulaba wuuyo ali bulindaala agamba leero kamani mbaya Besigye agenda naye political leaders basazeeko nawe kati nuuku naye kikirirwa secretary general. I think this is kino kiraba kiraga omukwano kiba kiraga omukwano kitegeera kiba kiraga omukwano. So all you need to do is to subscribe, like, comment and share the link. If it's your first time here, guys, if it's your first time here, just subscribe, like and share the link. Click in the notification bell so that you'll be updated on whatever we upload here. Nga buli mukulaba abantu bangi baweramuku olwaleero bazze okuwulira omusomo gw'omukulu Dr. Besigye. Abantu bangi nnyo ddala bona bulaba nyo bazze agamba leero tutuukirire era microphone bagisibye naye gwe waawo tetwakoze bakakiiri bananga abamaniyo malamusiza matumidde abamaniyo abali mu kulaba oba oli wa Arsenal nange ebyo bibaawo abamaniyo tubatumidde awo aba Arsenal namwe tubatumidde ebitabo bibeera abakulemu nakibakulemu naye nga musharinga vidiyo sharinga tutambuze ekintu kino mpola subscribinga likinga ate era commentinga lunaku lwaleero olowoozaaki what do you think olunaku olwaleero ekigenda okuba nga kibeerawo waneeno mukooti tegedde ekintu naye nga political leaders nabo we bali nope ekiikiriddwa omukulu secretary general mu David Lewis Lubongoya so tulowooza nti nebintu byakusaaga Lord Mayor senior council bonna batuuse dda tulina okukola kulindirira tulabe munnange era namutudde kumpi wano era nga bwondaba teri kifaananyi era bwe tunaafa Solomoni Davitere omanyi ensonga weeri Solomoni kasifa mwena mumanyi yaife mukuddo kyengera town council Kiza Muhammad. Alright, thank you so much Kiza for subscribing. Thank you so much. If it's your first time here guys, subscribe. Hey, subscribe. Yeah. Mwewale kubanga mufunire extreme media UB baagala nagenda okusinzira okubanga mulaba omusango genda kuwagulirwa tulabe munnangi nogera okujjukiza nti esadde byawedde ngaabadde babataddeko obakyagiza emisango ne bagigaana emisango gyo ne bagigaana so kati tolina okukola kiri kimu subscribing, liking, commenting. Mafuna tripod, mafuna stand. Bazibula. Alright, mwana mwewale kutuweereza Procedural nawe webale kusiima kyakabiri oli ku extreme media UB ebanga eriyo walala oli mukulaba yoba gyali mukulabirako kazoolya extreme media UB ng'osubscribinga ng'olikinga ng'ate era commentinga. You are watching Extreme Media UB. Jogeza Nicholas aka John Paul UB. And Extreme Media sharing. Renga tutamze live. Thanks for your service. Okay, I'm waiting. I yesterday morning. Yes, yesterday morning. Omusango nakuba ngutandika okuwulirwa anytime from now. So all you need to do is subscribe. Nga wettuwa endowooza, what do you think? Olunaku olwali ekigenda okwolebwa people are very many here. Abantu bangi ddala soka tufuneko abantu ab'enjawulo.
Individual, in addition of the other individual who is now part of the original case, certainly also sends a signal that this is the use of tramped churches where they have been quartered their games. We're now living nothing to chance. This is I know there are doctors in the entire system, people who believe in the prosperity, unity, and the progress of this country will put their time and effort together to help you gonna get a better story. We're in this together. First of all, we want to thank our brothers and sisters in Kenya that are standing solidarity with us, that focused on the regional spirit and the regional family, to know that an attack on any one of us, an attack on all of us. But also we expect that, as a country, we've gone through enough, and we feel this is the right time for us and for everybody to say enough is enough. It cannot be business as usual, and I'm happy that everybody, including those that support the system, are getting to a point where the appreciating that, look, this is not going to be a business as usual. And just like you had from the proceedings yesterday, court order, an MRU, extradition treaty, and things that border to the international law system have been broken. And I believe that these people have run out of excuses, and I towards that today they have an option but to give us a judgment that is in our favor, to allow Dr. Besigye and those that are incarcerated, illegally detained, to get their freedom today, because just like, very finally, just like it is crystal clear that if you claim or you purport that somebody committed a crime while in Greece, Switzerland, or Kenya, there is no court in Uganda under the sun or underneath the sun that has the constitutional power, constitutional influence, and constitutional authority to even hear, not even determine this process, but to even hear, not the Supreme Court, not the Constitutional Court, not the higher court, the High Court, or such courts in Uganda that are sanctioned by an act of parliament. So this is an illegality, and it's going to be quest and thrown in the low garbage bin that it deserves today. And basically, that's what I believe is going to be the outcome, and that is the expectation that we have today. Appreciate it. Thank you so much. Appreciate it. No problem.
Yes. Uganda doesn't slide. BBS for politics. BBS. The speaker has spoken. Follow it.
yagana guys babadde batukoze kimulina omumanya abadde batugaanye ndi mukubalagirani mu nkukutu akategedde bya nkukutu tuyumba abadde batutopinze naye nze gitwozize mu magezi akategedde. Yeah, they had stopped us. So they had stopped us from streaming. But I explained them how to be on. Okay, so you need to subscribe. Yeah, we are almost starting. Mwe bino ebintu bya struggle baba bizibu kyemulina omanya abadde batustopinze naye tugenda kuba tukubereza buli kimu kyonna kyekiri tetugenda kupowa mu magezi ekyomanya abadde batugaanye. Bano bibadde bikalubi.
Appearing for the state is Kano Lieutenant from there, Second Lieutenant Anthony Phillips, and Second Lieutenant Regina Meza.
Chair, members, my name is Alice Bella. I am led by Senior Counsel Martha Barua, Ilias Magu, Mr. Kugume Yesi Moses, Ms. Kumihira Oskovia, Mr. Ugur Silas, Mr. Nigel Peter, Brian Kama, Musime Kiko, Mr. Chief Michael, Mr. Second Jacob Rebecca, Mr. Kato Wilson, Mr. Melkola Universe Elias, Honorable Chiwanuka Abdallah, Godfrey Chimpa, Wanda Ronald Samuel, Frederick Banga, Apollo Katumba, Mr. Kabuye Lawrence, Mr. Secretary Julius Paul, Mr. Samuel Mulizi Mulindwa, Mr. Ivan Nigowe. I think that is the list of council that we present this morning. That's the team, Mr. Chairman.
We are ready to receive the remaining report.
Uganda, Uganda People's Defense Forces, the General Court Martial of them at Makiri. Case number 2024. Uganda versus A1 74 Captain Louis Scholar, A2 Arabo 0098, and of that Dr. Tiza Besigye, A3 has obeyed the challenge. Ruling of the court, the objection raised on 13th January 2025, Colonel Raphael Muchakanso for the state applied to amend the charge sheet by adding Captain Dennis Ora as the third accused person and the preparation was allowed. When it came to predating, counsel for Colonel Dr. Chiza Besigye, led by Martha Karua, Yasu Kwamu, and Ernest Kalibara, raised the following objections in the back of his trial before this court. That this court has no territorial jurisdiction in pertaining charges. That is not clear as to the defense forces were that how the accused persons, but that how the accused person was brought before the court did not follow the due process of the law. Our counsel cited this court the case of Omar Awad Omar and 10 others versus Attorney General Consolidated Constitutional Provision number 55 and 56 of 2011, and submitted that the accused person was illegally brought here from Kenya to Uganda, having been abducted. That section 208 and 209 of the UPDF Act that appears to grant the court jurisdiction contravenes Articles 79 and 129 of the Constitution. Counsel read that this court finds meeting the objection and discharge the accused person. In the reply, Counsel Raphael Mucha for the state submitted that jurisdiction is a creature of the statute, and therefore section 208 of the UPDF Act gives jurisdiction to this court to try the accused person. Our counsel further submitted that the words defense forces are defined in the UPDF Act to mean Uganda People's Defense Forces, and therefore the submissions of counsel to the accused are misconceived and should be ignored by this court. Our counsel further submitted that section 117G on aiding and abetting, and H on being found in an unlawful possession of arms or ammunition brings the accused person before the jurisdiction of this court. Counsel further submitted that the accused person was brought lawfully through the memorandum of understanding between Kenya and Uganda on interstate arrangement on defense and security for offenders involved in committing or suspected to have committed serious crimes like terrorism, among others. Our counsel further submitted that the constitutional provisions cited in this matter are not applicable. That is Article 23, 28, Clause 7, 12, 126, 129, and 79. Counsel further submitted that there is no difference in the charge sheet as alleged. In the remainder, counsel for the accused submitted that in the case of Omar Awad Omar, the Tanzania case of Mataka versus R was distinguished. Counsel submitted that in the number of cases cited in Omar Awad, above where there is evidence of abduction, then the court has no jurisdiction to try the accused person. Lastly, counsel retaliated earlier prayers that the court finds merit in the objection raised and discharges the accused person. This court, after listening to the submissions of both counsel for the accused and the state, considered the relevant laws relating to this application as deliberated on this application and finds as follows. One, that jurisdiction is a creature of statute and section 208 of the UPDF Act gives powers to this court to try any person who has committed an offense in Uganda and outside Uganda. Two, that there is no defect in the charge sheet because the accused is charged under Ugandan law, the UPDF Act, which act clearly defines defense forces to mean Uganda People's Defense Forces. Three, on the submissions that the accused person was abducted and brought to Uganda without following due process of the law. This court finds that there is no extradition treaty between Uganda and Kenya that was breached. To the contrary, this court finds that the accused being brought to Uganda through a memorandum of understanding between Uganda and Kenya on defense and security for purposes, solely for persons suspected to have committed serious crimes did not amount to abduction. This court has considered the consultations of the Constitutional Court in Omar, and others which were cited by counsel for the accused from paragraph 25 on page 63 to 74 of the judgment and entirely agrees with the court. For on the submission that section 208 and 209 of the UPDF Act that appears to grant this court jurisdiction contravenes Articles 79 and 129 of the Constitution. This court finds that it is not true that section 208 of the UPDF Act appears to grant jurisdiction, but actually gives jurisdiction to this court to try the accused person. Jurisdiction being a breach of the statute, and this court having addressed itself to the provision of Article 79 and 129 of the Constitution. This court finds the cited articles not applicable in this application and finds that this court has jurisdiction in the case. Accordingly, the objection raised are hereby dismissed and the accused person should take plea. Sorrow done at McKinley this 14th day of January 2025, and my hand and receive this court. And with that, we are proceeding from where we had stopped yesterday to Colonel retired Dr. Chiza Wesley.
May you please use the Chairman? We have a matter of law to raise.
About the rule?
Yes, Mr. Chairman. And Mr. Chairman,
hold on, Council.
okay, we make case for
Still it around.
so if there may be around such it's a matter of law, it's a matter which touches the constitution. So we have to prepare to make this decision.
And that's why this is my advisor. It's about law. Let him advise and then
the issue is about making prayer for constitutional finance, and the prayer will be permitted to do so, Mr. Chairman. And if it's a matter of constitution, it takes precedence over any other issue. And that's the reason we are seeking for the audience to permit us to make a case for a constitutional reference led by my colleague here, Councilman. That is our Mr. Chairman. We make a case for constitutional reference. And if you do permit, Councilman Barrow proceed to take a lead in this in light of the disagreement. And I would like to emphasize that where a constitutional matter is raised, it takes preference over any precedence level, over any other matter. So, beg that you permit us, Mr. Chairman, to proceed about the case for constitutional reference.
I have no problem with your submission, Council, but what I'm saying, he advises the court on law matters which you are going to raise. I have finished the ruling, let him advise, and then you'll be given time if it is allowed. I don't know what you are laughing. And I don't understand what it means, because
I think, sir, if you has any points to raise on the matters of law, the procedure is that you can urge out your case, the state will respond, and this court will also rule on that matter, whether what you have raised requires the reference to the constitutional court of law. So you can proceed.
Excuse me, I wanted just to know, why are you laughing? Hold on. Unless you don't know it, maybe he has advised, that's what they wanted. I think the council can proceed. Thank you. Go on.
Thank you, Honorable Chair. Honorable members. Following the ruling that has just been delivered, our instructions are to seek for the reference of a number of matters. The ruling has itself interpreted articles of the Constitution and found them inapplicable. That role is a role that is reserved for only one court in this land, Constitutional Court. But Mr. Chairman, I want to preface my application for the reference by taking the court to Article 208 of the Constitution. That article, Mr. Chairman, establishes the UPPF. And it spells out a number of very good attributes for the UPDF: patriotic, professional, discipline, and so on. Those attributes, in fact, distinguish the UPDF from other previous enforcing procedural. So they are quite impressionable and quite useful. I think that they are amazing attributes to have. I have found them also on the UPDF website. So the UPDF itself is aware of what these attributes are. One of the most important attributes in Article 208 is that the UPDF is subordinate to the civilian authority. Established under the Constitution. Mr. Chairman, what that means is simply that the force, its members, and its organs are all subordinate to civilian authority. In fact, the courts are referring you to a number of cases. The courts have made pronouncements to that effect. And we contend that in the finding that you have jurisdiction in this matter, the General Court Martial is putting itself above civilian authority. And I'll explain what that means. Mr. Chairman, our Constitution is a very, very important document to us. The preamble tells us all the things that were wrong with this country. It tells us the things we aspire to. And it also says these are the ideals we should pursue. And in saying so, it wasn't about 1995 when it was promulgated, but it was to continue up to eternity. That same document also gave us a chapter 4, which covers many articles of human rights and so on. I'm going to refer to 28 shortly. But the force, the UPDF, must live by what the Constitution declares. In addition to what I have just said, that same Constitution says that the rights of all persons, including abused persons, are inherent, so they are not granted by anybody, not any organ, not any person. They are inherent. And they can only be taken away in the manner that the Constitution has said they can be taken away. So I will start with Article 28, and the right to a fair hearing. Honorable Chair, the right to a fair hearing has been described as that Article 28 as a culmination of Uganda's struggles against forces of tyranny, oppression, and exploitation that brought about unconstitutionality and political instability. It is one of those articles that cannot be derogated from. So there are no circumstances at all under which one can ignore or disapply or fail to observe that specific article. One of the most important aspects of that article is in Article 28:12. Article 28:12 provides, except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is the. So Article 28:12 requires that every offense is clear. The idea around definition is that when you read it, you know what conduct amounts to an offense and what conduct does not amount to an offense. And it cannot be derogated from. So if we have a situation where it's not clear, then we are derogating from Article 28:12. Mr. Chairman, the charge sheet has an offense which is described as offenses related to security. It is contrary to section 128, 1F of the UPDF Act. Perhaps let me read it out. Paragraph F is to the effect that if you do or omit to do anything with intent to prejudice the security of the defense forces, you commit an offense. If you do or omit to do anything, so to walk into, as a civilian, I could walk into a military barracks. I could be charged with that. I could be charged with that offense. If I am a cook and I decide that the porridge I have been asked to make for this morning has, in my assessment, issues, and I refuse to make the porridge. And as a result, people go out in the unit and they are hungry, they are pushed and they have no energy to fight. And can be charged with that offense and be put to death. That is if I refuse. If I don't refuse and I make the same porridge, knowing that they also may have an issue, but we have to eat. People have to go outside, and people go out on the road running stone. I can be charged with that offense and put it to. If you do anything, if you omit to do anything. Now, Mr. Chairman, it would be useful if the court looked while it's considering this application, looked at the rest of the paragraphs, 128(1)(a) to E, because they are very specific as to what it is a person could do. Disclosing by word of mouth the document, information to the enemy, that is clear. Discussing confidential information, giving a password to somebody who is not authorized. That's clear. And then at the end of that whole section, if you do anything or omit to do anything, Mr. Chairman, I contend that the offense is not defined. Article 2812 deals with, gist of it, the purpose for it is to ensure there is no vagueness. So it is the constitutional standard to deal with vagueness. And why is there a problem with vagueness? Is simply because you can have overreach. The application of the section depends on the whims of a person who decides that it applies or doesn't apply. The gentleman making porridge, the gentleman refusing to make porridge. If I disarmed somebody who is perhaps drunk and I assume that he is becoming a danger until 6 p.m., I have nowhere to take the weapon that I have taken from him, I maybe have to hold it up in the air shouting that, no, I have just disarmed this person, I'm not committing an offense. There is a big problem in our assessment with that provision. So, Mr. Chairman, it is the contention of the accused person that that offense is written in words that clearly show that the people who drafted it had run out of it, the clarity. They just said, let's just also put a net to see what else we can catch. We want to catch Nile perch, but let's put a net. If we also get mopene, we get worms, we get stones, it's okay. Let's just try. But the whole intention was we wanted to get Nile perch. So, Mr. Chairman, honorable members, it is our contention that there is a question that arises with regard to section 128(1)(f). The question that I will pose to the court is simply this: whether that section 128(1)(f) of the UPDF Act is defined in terms of, and therefore consistent with Article 28(12) of the Constitution. Honorable Chairman, General Court Martial cannot answer that question because, as I said earlier, the role to answering these questions is the preserve of the Constitutional Court under Article 137(1). We trust that the Court Martial, as part of the UPDF, the law-abiding citizen institution, which is why I refer to the attributes of the force which must be professional and disciplined, and is aware that it must subordinate itself to the provisions of the Constitution, will find this question one that will be referred for interpretation. Mr. Chairman, there is another question that we would like to also pose. And it's a question that has arisen here separately, but continues. And it is so fundamental to the trial of especially the two civilian gentlemen that it's imperative that it be addressed. Mr. Chairman, again, Article 28, Sub-Article 1, spells out the standard that is expected, that is required, from which there can be no derogation as far as a fair hearing is concerned. Fair, speedy public hearing before an independent and impartial court. Independent and impartial. The cases, Mr. Chairman, that have dealt with the issue that I am addressing you on, the trial of civilians, are many. Captain Amon Bialgaba is one such case, 2015. Attorney General, Uganda Law Society versus Attorney General, 2005. Attorney General Joseph Shabe, 2005. Michael Kabaziguruka, 2016. They have all said the same thing. And that thing is that with the setup that exists in the structure of this court, it is impossible for there to be a fair hearing. They have addressed questions of independence. They have addressed questions of impartiality. And I say this, Mr. Chairman, with all the humility I can, all the respect, but taking you back to the attributes of the force being subordinate to civilian authority. The judiciary has said this is the position. Then the force and its organs must subordinate themselves to that position. Because to do otherwise, Mr. Chairman, is to say that the force, that its organs, that the officers and men, the wonderful officers and men that constitute that force, can rise above the Constitution. If that route is taken, if that view is entertained, if that thought even crosses the mind of anybody, then the entire 150 words of the preamble that I spoke about are useless. We head right back into tyranny. We must distinguish ourselves from those forces that do not abide by the Constitution. Mr. Chairman, in light of those decisions, ones I have cited, and I know Helen friends will say one of them had a stay. It is true, it has a stay. It is a stay on implementation, not on interpretation. And when you read Amon, Captain Amon Bialgaba, the court there was very clear. Until the apex court has pronounced itself on the interrelated issues, the paragraph dealing with Kabaziguruka. Michael Kabaziguruka, the Attorney General, as well as ULS and the Attorney General, both of which I have cited, remain good law for the present purposes. Mr. Chairman, the law now is as interpreted by the Constitutional Court. But we can't be here to deal with civilians. Even if we want to, we can't. We can't. Unless we are elevating ourselves above the Constitution. If we are, but if we are not elevating ourselves, then we must abide by what those decisions say until there is a contrary decision. There is no, the stay, I'm sure my last friend will refer to it, the stay does not remove the interpretation. The importance of the Constitution, I don't know what words I can use to express how important it is to abide by the Constitution. Mr. Chairman, the question I would like to frame, propose in framing, is this: whether in light of the decisions of civilian courts, both the Constitutional Court and the Supreme Court, regarding the trial of civilians in the court martial, the conduct of the General Court Martial as an organ of the UPDF, to try two civilians is consistent with Article 2082, the one on being subordinate to civilian authority. 128(2), Mr. Chairman, 128(2) is that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure the effectiveness of the courts. Effectiveness of the courts includes its judgments being binding, being applicable to everybody, until there is a contrary position. Michael Kabazuka was decided about 4 or 5 years ago. There has not been a contrary position. I would pray, Mr. Chairman, that that question also be allowed. We had proceedings still in Article 28, 1 on the impartiality, on the nature of the tribunal, and there is a question that arises about how impartial tribunal, an organ of the defense forces which investigates an offense, charges the accused, tries the accused, can be considered impartial in any way. And this is not to say anything about the character or the fine officers and men who constitute the court. It has nothing to do with their individual. It's the institution. How can you be a judge in your own cause? What? How else can you find prejudice other than being a judge in your own cause? The church tells us about offenses related to the defense procedure. So when we ask that these matters move away from here and go elsewhere, we are simply following what the Constitution requires. Yesterday we had this engagement with the judge advocate, a good friend. But from this side and that side, we're always having contestations. But just for purposes of impartiality, the panel, and also yesterday we went through what the panel insists on. But we found that the regulation, this is just an example, Regulation 69. So yesterday we had an issue around the judge whether his views are binding or not, the advice given and so on. I'll address that shortly. But there is also another one which I want to give by example. 69.2 says that a court may adjourn, it is referring to the court martial, may adjourn at any time to consult the convening authority on a point of law. This court is supposed to be complete as a unit, discharging its work alone. Everybody who is a member of this court should be in the court. I checked who the convening authority is. It's the High Court. If the court will adjourn or can adjourn, is empowered to adjourn, is allowed to adjourn to court, consult the High Command. Mr. Chairman, Article 28.1 would have no place. But this regulation cannot apply above Article 28. Impartiality. So, we also pose this question. In the circumstances where we are, where the defense forces are the complainant, the investigator, the witnesses, the judge, is a trial before the court martial consistent with Article 28? Is it? Can it be usurpated? That question needs to go for interpretation. There are other factors dealing with impartiality. They have to do with the tenure, security, tenure, and so on. So in the other civilian side where we are maybe a little bit more familiar, we know that there is sanctity. There are provisions that protect, that reinforce, protect the judicial officer, and reinforce the idea around impartiality. No, we don't. So we have a challenge. Going back to the judge's advocate, if the court is bound by the advice of the judge, who is not a member of the panel, who is making this decision? And I say this, I have said again, I will emphasize, it has nothing to do with the character of the individual. It has something to do with the structure of the law. If indeed my learned friend's advice is binding, why is there a ban at all? So, Mr. Chairman, I want to pose a question. The judge advocate's power is in Regulation 63.2. Whether Regulation 63.2 and 69.2 over the UPDF rules of procedure regulations are consistent with Article 28, one of the Constitution. Honorable Chair, Article 137 of our Constitution deals with the interpretation aspects. The interpretation of the Constitution can be done in two ways, one by way of petition, the other way by way of reference. Even the one of reference has two limbs. One where the court itself considers it necessary, if in its opinion is a substantial question. But the second one is where the party, the proceedings requests for a reference. The word used is that the court shall refer. If any party to the proceedings requests, the court shall refer the question to the Constitutional Court for a decision. When that reference is made, the case will be disposed of in accordance with what the Constitutional Court has guided. Mr. Chairman, the fourth question arises. Perhaps this morning also. And it has to do with Section 208 and Article 79.1 and 129.1 of the Constitution. We want to ask the question whether that Section 208 is contrary to and contravenes Article 79.1 of the government of Uganda. Parliament doesn't have it. We contain 129.1 has to do with judicial power in it of Uganda. So, in our view, Mr. Chairman, it is a question that we want to be interpreted. The place of Section 208 and Parliament. Honorable Chair, the framers of the Constitution, who incidentally also include one of the accused persons, envisage that at one point, as life goes on, there may arise a contestation between individuals and the state, and organs of the state. That is what this 137 is all about. So, Honorable Chair, as I end, my colleagues will supplement on other questions, but as I end, it is our contention that there are very serious questions that have arisen, which on the face of it, and this is the only requirement from the authorities, on the face of it require interpretation of the Constitution. They are not before a field court martial because that is the only time, that is the only court where you can't make reference. In all other courts, you are allowed to make reference. The parties empowered to make the request, and when they do so, the court shall refer the question. I pray that the four questions that I have posed be accepted and the reference be made on those and any others that my colleagues may add. Mr. Chairman, before I sit down, I also want to draw the attention of the court to another law, the Human Rights Enforcement Act. The Human Rights Enforcement Act is now Cap 12. In Section 11, the consequences of derogating from non-derogable rights of the person are spelled out. Those who do so commit offenses. That's the first consequence. And as far as that consequence is concerned, the offense, even 10 years later, the person who committed it can be charged and is liable to sentence of 15 years. When derogation is brought to the attention of the court, that's the second consequence. The court is required to declare the trial invalid. It's a heavy burden is a serious issue. So if we try civilians, contrary to Article 28, non-derogable right, in the face of decisions of civilian courts to which we are subordinate, we are committing offenses. In fact, the court is required to declare that trial nullity, acquit, and discharge the accused person. The defense forces are capable of abiding by the Constitution and human rights enforcement. This court, I am sure, is capable of abiding by the Constitution and the human rights enforcement. And I invite it to do so. We utmost respect. Mr. Chairman, I'll invite my other colleagues to supplement. But that is our prayer this morning.
Thank you, Mr. Chairman. I'm adding, Mr. Chairman, for emphasis, and my colleagues will come with other questions. Mr. Chairman and members of the court, the first question my colleague raised, I agree with him entirely, was in respect to the uncertainty of the offense, whereby when you do and do not do, you commit an offense. So if we are crossing the road, essentially we have an officer saying don't cross, so that when you cross, you are disobeying an order. You have one on the other side saying cross, yet when you cross, you disobey the other. The point I'm making, Mr. Chairman, is that the necessity for a law to be clear, not only to members of the distinguished UPDF, but everyone, is just so that they know when they are conducting their affairs, when they are out of the law or within the law. And for emphasis, Mr. Chairman, again in the case of retired Captain Ahmed Biarugala and others versus the Attorney General, Consumer Petition 44 of 2015, the court addressed itself. I will just refer to a short quotation so that I can emphasize. Citing an American case, Colonial versus Lawson, the court was of the view that, as generally stated, the void for vagueness doctrine requires that a penal statute defines the criminal offense with sufficient definiteness that an ordinary person can understand what conduct is prohibited and not prohibited, and in a manner that does not encourage arbitrary or discriminatory enforcement. The rationale, Mr. Chairman and members of the panel, is that I should know whether to cross the road or not to cross the road is an offense. That was an example. But also, it is intended for an ordinary man. Mr. Chairman, in society we have individuals who are high up there. We have individuals who are in the middle, what we ordinarily refer to as reasonable. They are not far off. And then we have the others who are lower, who in different aspects are referred to as the riffraff of society. The requirement for a law to be certain lowers itself to the lowest in society. The law should be very clear that an ordinary person, the lowest in society, is very sure about how they are going to conduct themselves. And that was the submission that offense which says to do anything or not to do anything that constitutes or compromises the security of the defense forces means that I am effectively at a cross junction. I don't know that to go left, right, north, south, east, or west. The other one, the third question my colleague raised was in regard to the court being impartial. Mr. Chairman, the courts have recognized that military courts, like the one we are in, is intended to charge or to try officers for disciplinary matters. And of course, in our UPDF Act, there is a clause which brings in the civilians. But again, Mr. Chairman, the courts have made a pronouncement about the character of the military court, it being appointed by the executive, and therefore the officers forming the courts being subject to the executive. And the courts have made it clear in the case of the Second Lieutenant Ambrose Ogwan versus Uganda. It says that courts which have to try any civil or criminal matter must be independent. It's a command. Under Article 28(1), and the courts have said by virtue of the appointment of the military court is not independent. Mr. Chairman, we are not making or referring to the individuals because who are before us, or before whom we are standing, because we know that theirs is an appointment and they are executing the lawful mandate of their appointing authority. So it's not character of individuals, it is the institution, Mr. Chairman. Because I've said military courts are not independent and that they are military courts of the executive, they belong to the executive. Moreover, the charges they try are brought by the army. And Mr. Chairman, the court made reference to two sets of people. Those who are not subject to military law, I suppose like me, and those who are subject to military law. I reckon, Mr. Chairman, like yourself, Mr. Chairman, and the officer before us, because they are soldiers serving, doing a national duty of protecting our country. But he said that persons who are subject to military law, like every other person in this country, enjoy fundamental rights which may only be limited in the manner allowed by the Constitution. He said that judges of independent courts cannot be under the administrative control of the authority that brings the charges. In this case, my Lord, Mr. Chairman, rather, to the extent that the court is of the institution of the UPDF, and the offense that has come, one of which is to compromise the security of the UPDF. Again, it shows that the institution which placed all these gallant officers in their offices with the executive is complaining before them. Put simply, because Mr. Chairman, I'm a parent, I have a grown-up child, and I am offended by my neighbor, Mr. Kalibala, and I constitute a panel of my children to try the matter where Mr. Kalibala is accused, and I am the complainant. The likelihood that my children will find against me when I buy their clothes, uniform, when I pay their salaries, is unlikely. But more importantly, in the eyes of Mr. Kalibala, he's not likely to see that as a fair process, because after all, the person charging him is one who I can direct to attend to me by instruction. And they must attend to me whether they want it or not, because as officers, you answer to the high office. Mr. Chairman, in that respect, the courts have taken note of individuals who are subject to this law and said that officers and militants of the Uganda People's Defense Forces do not, by joining the UPDF, surrender their rights and freedoms on account of joining the UPDF. We are thankful that today we have name tags. If I turn around, I can see Mr. Walimbwa. He doesn't surrender his rights because he has joined national service in terms of the UPDF. He enjoys the same rights as I enjoy. So if in one dispensation, I am entitled to a fair and biased court, we are the same, all of us wearing the same image, and therefore he's entitled to the rights and joy. So the courts have said that such rights and freedoms are available to the officers and the militants of the UPDF because they are available to all the other Ugandans who live in this country because they are inherent. The other point, Mr. Chairman, my colleague referred to Article 137(5)(b) of the Constitution. He alluded to a question which the court comes across and a question which is a request by the party. To be certain, Mr. Chairman, in this case, it is the accused persons from the amended charge sheet A2 and A3 who, through their counsel, are making this request. In that regard, the Constitution, which my colleague has repeated many times, is superior to the government of the UPDF, commands all courts, including this one, to frame a question and forward it to the Constitutional Court. It does not allow this court the opportunity to determine whether there is sense in raising that question, because that is not its duty. To determine, upon response from our colleagues, that we can examine the validity of that question, or if in their view, the question has been had before, is to defeat the Constitution. Mr. Chairman, Article 3 of our Constitution says that anyone who acts in breach of the Constitution creates a very big offense, which perhaps, again referring to Mr. Walimbwa here, will now bring him under this court. It is treason. So, we are urging the court, Mr. Chairman, that once we raise the questions that we have done, the honor or the duty of this court is to put the question in proper wording and send them out, and not to determine whether the questions should be sent, because the duty that it has been done already, there has been a request. Mr. Kalibala also referred to the Enforcement Act of Human Rights and said derogating from a non-derogable right, Mr. Chairman, is an offense. That should be Section 11, and that is true. As officers of court, Mr. Chairman, we do have a duty, perhaps akin that of the judge advocate, to advise the court. It is a duty we ought court as officers of court. What Mr. Kalibala did not say, Mr. Chairman, is that while people executing office have got immunity of office, this particular act waives that immunity. So the judge advocate, if it becomes aware that this court is deviating from he's not part of the court. If any of us became aware that we are deviating from a non-derogable right, we are committing an offense. And that offense is alive for between 10 to 15 years. Moreover, the defense that I was acting under instruction does not arise. Mr. Chairman, in 15 years, I will be nearing 65. So I wouldn't want my younger colleague here to keep it in his heart and after 14 years come against any of the distinguished officers there to say on the 14th of May, he took the view that they were derogating from an underground right. Because the defense of saying we are executing our mandate of officers established under an act of law will not be available to distinguished members. That is the command of the law. Our request, Mr. Chairman, seeing that my colleague referred to the attributes of a force which is patriotic, which is disciplined, and a disciplined individual or institution agrees with established rules and principles, and even that the same command the force to subject itself to civilian authority. We do request that as commanded by Article 137(5)(b), which directs the court to submit the question, that when my colleagues have raised the questions, we do not engage the chairman, and make most politely, with questions as to whether we should refer, rather, we spend the other part of the day by getting the right language of the questions, which shall then be referred to the Constitutional Court to interpret as they are mandated to do under Section 130, Article. Mr. Chairman, again, and for my colleagues from the state, led by the prosecutor, we just want to refer you, when I say my God, it's not derogatory, the court, to Section 195 of the General Court Martial, which spells very clearly and succinctly the functions of the General Court Martial. My Lord, Mr. Chairman, that section has 3 subsections, and the first subsection has got 5 paragraphs, none of which don't give this court power to interpret provisions of the Constitution or of any other law. Therefore, request that to surrender to even replace this court, and the questions be crafted with the aid of our colleagues and ourselves and sent to the higher court for the next interpretation, so that if we are to return here following the finding of that court, we are sure that all the doubt we had about jurisdiction, about impartiality, about extraterritorial effect, which are now the heading points, are handled, and that we can proceed peacefully and in a manner that is subject and under established law. That is my request. I thank you, Mr. Chairman, members of the panel, for listening.
Thank you, Mr. Chairman and honorable members. The 4 issues framed by my learned friend here are well canvassed by my colleagues here. Will permit me, Mr. Chairman, to add on to those 3 issues. But before I do so, Mr. Chairman, just 1 to 3 minutes to reinforce the 2 issues, the first 2 issues on Council Kalibala raised with authorities on them. The arguments have been adequately canvassed, and we are convinced this honorable court is persuaded by those submissions. Now, with authorities on vagueness of Section 128, that is issue number 1. Vagueness, the uncertainty of that particular provision. The Constitutional Court has had occasion to pronounce itself on that particular matter in the case of Andrew Karamachi. I'll furnish you a copy with you. Brother, I'll furnish you the copy. Andrew Karamachi, Robert Shaka versus Biafra. It's constitutional petition number 5 of 2016. Can you get the copy? But the point emphasized here, Mr. Chairman, the doctrine of evidence in legislation. This is what they said on page 10. This is the constitutional point. The doctrine of vagueness is founded on rule of law. The doctrine of vagueness is founded on the rule of law, particularly on the principles of fair notice to citizens and the limitation of enforcement discretion. Fair notice to the citizen comprises a form aspect, an acquaintance with actual text of a statute, and a substantive aspect, an understanding that certain conduct is subject to legal restrictions. The crux of the concern for limitation of enforcement is that the law must not be so devoid of precision in its content that a conviction will automatically flow from the decision to prosecute. The threshold for finding a law vague is relatively high, and this is what they set as a standard. The factors to be considered in determining whether the law is vague or not: A, the need for flexibility and the interpretative role of the courts, that is number 1. 2, the impossibility of achieving absolute certainty. A standard of intelligibility being more appropriate. That standard of intelligibility is critical and crucial. 3, the possibility that many varying judicial interpretations of a given disposition may exist and perhaps coexist. They cited the case of Nova Scotia Pharmaceutical. It is a 1993 decision which you find here. So the doctrine of vagueness can be summed up in one proposition. This is how they sum it up, the Constitutional Court. A law will be found unconstitutionally vague if it lacks in precision as not to give sufficient guidance for legal debate. That is, for reaching a conclusion as to its meaning by reasoned analysis applying legal criteria. The term legal debate is not used. The term legal debate is not used to express a new standard or one departing from that previously outlined by this court. It is rather intended to reflect and encompass the same standard and criteria of fair notice and limitation of enforcement discretion viewed in fuller context of analysis and the point and limits of human knowledge and understanding in the operation of the law. The criterion of absence of legal debate, and so it continues and continues. And finally, Mr. Chairman, this is the decision they arrived at after analyzing all that. A statute is also void for vagueness if the legislature's delegation of authority to judges or administrators, like this General Court Martial, is so extensive that it would lead to arbitrary prosecution. I need to emphasize this. A statute is also void for vagueness if a legislature's delegation of authority to judges or administrators is so extensive that it would lead to arbitrary prosecutions. Vague laws involve three basic dangers, and this is what we want to caution against. This is what they stated. Vague laws involve three basic dangers. 1, they may harm the innocent by failing to warn of the offense. Ignorance of law is not defense, yet the law itself is vague. 2, They encourage arbitrary and discriminatory enforcement because vague laws delegate enforcement and statutory interpretation to individual government officials. Laws are usually found void for vagueness if after setting some requirement or punishment, the law does not specify what is required or what conduct is punishable. Also, an enactment is void for vagueness if its prohibitions are not clearly defined. Finally, Article 28(12) is very clear. It requires that an offense must be defined. That definition, in my view, must be clear enough to enable citizens to distinguish between the prohibited conduct and the permissible one. Any vague interpretation will lead to satisfy the requirement of Article 28. In fact, the case of Charles Onyango versus the Attorney General. So this is authority by the Constitutional Court, which has got that primary obligation of interpreting the Constitution, is binding. And it's very instructive in that when you look at Section 128, it opens floodgates. It cuts the net wide offenses relating to security and punishment. This is how serious it is. So a vague law to subject somebody to a death penalty is something that cannot be sanctioned by the existing constitutional order. And the reason we are asking, we need interpretation of the constitutional court about that particular provision. So that is the authority in regard to the vagueness of Section 128 relating to offenses compromising security. The other issue, the second issue, again I would cite the authority, the issue relating to subjecting civilians to martial law, which my learned friend here adequately encompassed. But the authority, and he cited a number of authorities. Cited the ones of Uganda Law Society, cited Amoni Yagaba, and cited Kabasgroup and a couple of others. But the point I wanted to emphasize, there are two authorities that have come subsequent to the decision of Kabasgroup. One of Amoni Yagaba, which is 2022, and it was very, very clear. And on that one, there was nothing. The one of Yagaba. Yes, the Attorney General preferred an appeal against the decision in the Kabasgroup matter. But the one of Amoni Yagaba, there is no pen to that. There is no any order state and no any other far order in that regard. My learned friend alluded to the fact that the other side may raise a contention that there was an order of stay in the Kabasgroup case. That has also been subsequently handled by the Constitutional Court, which took a decision in that case. They have decided one in the case of Amoni Yagaba, but more sufficiently in the case of Semju Abdul Noor versus the Attorney General, Constitutional Petition number 4 of 2018. The most recent one, it is, to be exact, it is the 3rd February 2023. It is as fresh as these charges before you. This decision, the lead judge, may his soul, Justice Kakulu, may his soul rest in eternal peace, had the occasion to reproduce verbatim the decision in the Kabasgroup case. Sum them up. And he said, the constitutionality, no, I have carefully listened and considered the submissions of both counsel on the constitutionality of sections 119 and 197 of the UPDF Act. I have also carefully perused the affidavits and so on and so forth. The constitutionality of the issues raised above were substantially raised and settled in the recent constitutional decision of Honorable Michael Kabasgroup versus the Attorney General. That is constitutional petition number 45 of 2016. Then he said, I will produce the declarations in extension for clarity. He highlighted them. I will not take your time, but they are very few. Yes? Yeah, just number 5. No. the General Court Martial established under section yes. No, number 2, the General Court Martial's jurisdiction is only limited to trying service offences under the UPDF Act. Then, we say, B, military law under the UPDF Act must be construed to exclude laws that are the preserve of the civil courts of judicature. I will come to that later when I'm raising another issue. But more specifically, number 4, persons subject to military law. No, 5. Sections 119, 1H, subsection 1 of section 179 of the UPDF Act are unconstitutional as they are inconsistent with Article 28 of the Constitution. That is a finding which is well captured in the decision of Karasbuka and reproduced in a number of those decisions. And they had occasion to make this finding after listening to the submissions of the state that in the Karasbuka matter there is an appeal, there is an order of state. This is what the Constitutional Court said after listening to the submissions, which are likely to come from the other side when they are replied. This is the response and the finding of the Constitutional Court. The above authority is good law, and I am bound to follow it. We are well aware that the above cited decision is currently pending appeal at Supreme Court. Until the Supreme Court decides otherwise, the authority is still good law. The fact that gave rise to this petition are almost on all fours with those in Honorable Kazikura's case. Applying the above authority, I find that the petition is on all fours. The petition is therefore allowed on that account alone. The same declarations and orders in the Kazikuka petition apply to this petition. This is as of recent as 2023. So, this court, I'm afraid to say, its hands are now tied. Has no choice but to go by the declarations of the decision and reinforced in the decision of Semutu and Yagaba and others which have come subsequent to the one of the submission I will make here. Again, in emphasizing the point Fred Mpanga here has raised of Article 3, any attempt by this General Court Martial to proceed with the prosecution in total disregard of this finding of the Constitutional Court, with all due respect to the General Court Martial, to be treason. It will amount to treason for this General Court Martial to proceed with the prosecution, with the hearing of the matter, in total disregard of this, because the Constitution Article is very, very clear on the observance of the constitutional order, respect to the given constitutional order and interpretations given. So I urge you, Mr. Chairman, and members of the panel, not to commit treason by proceeding with this matter. Now, Mr. Chairman, with your permission, I beg to move and frame to 3 issues. The first issue, in addition to the ones, the first one is about the propriety of the proceedings, the charge sheet canvassing Mr. Chairman. Mr. Chairman, whether the trial premised on arrest and rendition of accused persons from Kenya in total disregard of the extradition law and other international laws, and on the basis of a memorandum of understanding which is not within the framework of the extradition laws, amounts to a violation of Article 28 of the Constitution. Mr. Chairman, in your finding this morning, you indicated that there is an MOU between the government of Uganda and Kenya to exchange people presumed to have committed offenses, which obviously is not premised on international law or the existing extradition acts or laws of both countries. So that is a matter which requires constitutional interpretation. Can there exist an extradition treaty outside? No, not a treaty, an MOU, yet the law provides for an extradition treaty. And isn't that a violation of Article 28 of the Constitution, which guarantees the right to fair hearing and other relevant provisions? So I don't need to labor so much because we added out that point earlier on. We have got to adopt the submissions we made earlier on about rendition in violation of the extradition law. So we like that issue matter also to be referred to the constitutional court. The other issue, Mr. Chairman, is the jurisdiction of this honorable court to deal with cases under the Firearms Act. Mr. Chairman, in this Kabaskuruka case, which is again reproduced in the subsequent decisions which I've just made reference to, particularly the one in Assembly. So, clause 4, paragraph 4 of the decision. No, paragraph 3. Military law under the UPDF Act must be construed to exclude the laws that are the preserve of civil courts of judicature established under Chapter 8 of the Constitution. And Mr. Chairman, this was a reinforcement of the decision in the case of Dr. Chiza Besigye, the very person before you here, in Constitutional Petition number 12 of 2006, where it was adequately, again, handled by the Constitutional Court, that the offense is not the one whose particulars appear in the charge sheet. The offense in the charge sheet is under Section 3, by then it was Section 3, now Section 4 of the Firearms Act. That offense does not fall under Section 193. I'm sorry, it may not be that clear, the photocopy was not clear, Mr. Chairman. That offense, Section 3(1) of the Firearms Act, which is now Section 4 of the Firearms Act, and it encompasses counts 3, 4, and 5. That offense does not fall under Section 119 of the UPDF Act. The offense of unlawful possession of firearms, ordinarily the monopoly of the UPDF forces. They said this offense is neither defined by any law in our statute books, nor has the sentence for it been prescribed. The said amendment of the charge, there was an amendment to the charge sheet, is clearly not helpful. They went ahead to say that government or UPDF attempted to come up with the instrument number 13 of 2006, ostensibly, I think, to address that lacuna. Uganda People's Defense Forces, arms, ammunition, and firearms, to define that phrase, monopoly of the defense forces. The court said that instrument was also redundant. And the beauty with this, my learned friend here was still the judge advocate, was involved in this matter and is fully aware of the facts in this particular matter and all the attempts that were made to address those legal challenges. In other words, their finding was that you cannot widen the scope of Section 119 to bring into operation the provisions of the Firearms Act or any other law, including a Suppression of Terrorism Act, which is a preserve of the civil courts. That would be overstepping the mandate of the General Court Martial. I can say incarnation of the same here in this very charge sheet. So what ordinarily ought to have been done is to define that animal, which clearly the animal code offenses which are ordinarily a monopoly, no, weapons rather, weapons which are ordinarily a monopoly of the UPDF. Up to now, ever since this decision was made, the Besigye decision, this animal is still anonymous, undefined. And the attempt to do so in this instance were also declared futile. So, Mr. Chairman, unless and until that phrase is unpacked and legally dissected and explained, this general court martial cannot try offences under the Firearms Act. So we would like that issue again to be also canvassed by the Constitutional Court. Finally, the issue I would raise is whether the arrest, conviction, and the detention of Counsel Aaron Chiza, one of the defense lawyers, amounts to violation of Article 28B of the Constitution. Mr. Chairman, Aaron Chiza is on record up to the present moment is one of the defense lawyers. And I'm glad when we raised it here and said, how do we cause the appearance of Aaron Chiza to execute his duties as per the instructions given to him and as per the record? There was the preponderance of doubt. And I read it on your mind. If I read you like a private researcher, you say, is it happen that the person convicted can also come here? Then the judge advocate was also similar doubt. The only forum where that doubt can be cleared is the Constitutional Court. And the Constitutional Court has had occasion, this is the last authority I'm citing. In this case, it's one of the locust cases on rights, fundamental rights, Article 28. Uganda Law Society and Jackson Kagaba versus the Attorney General. The lead justice, I think, was invited by the They gave a purposeful interpretation. Of course, this is the command of the Constitution and rules of interpretation to Article 128. Each and Article 28, each and every of the above Constitution, each and every of the above, rather not of the above Constitution, each and every one of the above constitute what the right to a fair hearing means. It was never intended that this would be an exhaustive definition of the right to fair hearing. Article 45 of the Constitution provides human rights and other freedoms additional to these rights. Mr. Chairman, during the trial here, during the hearing of the prayer we made about the appearance of our colleague, Aaron Chiza, the judge advocate here indicated and said, but you see, Article 28 talks of the right to legal representation. It does not specify the number. The answer lies in this decision. That Article 28, which talks about the right to a fair trial, is not even exhaustive when it talks about those key elements. It's the reason the CA had to insert Article 45. That there are situations that may arise that would warrant one to enjoy more than what you can even see. Why Aaron Chiza is indeed needed in this case can only be answered by the person who gave him instructions. He knows the reason and he should be facilitated to prepare his defense. And one cannot say, just especially from the other side, from the judge advocate, that what role is he going to play when the accused person has got over 30 or 40 lawyers. The prerogative rests with him to determine who should be there, who shouldn't be there, and to have a lawyer or lawyers of his choice. That is the language of the Constitution. Aaron Chiza remains his lawyer of choice for a reason which should not be derogated, because that is a non-derogable right, the right of fair hearing. Article 28 and 44 is a non-derogable right. So I reiterate the prayers made. I will not go into other issues. I beg that Mr. Chairman and the honorable members that you proceed to do what is commanded by Article 137 to refer this matter to the Constitution of the State. I beg you.
Because my colleagues have expounded on these matters. But I want to begin by reminding us that in Article 5 of the Constitution, Uganda is declared a republic. And then move on to cite several characteristics of a republic. Characteristics of a republic: there must be, the people must be the source of authority. And that's what the Constitution of Uganda says. Everything is done in the name, for, and in the name of the people of Uganda. The people must also elect their representatives to make laws and serve their interests. And that happens through parliament. In a republic, there must be rule of law. Law that applies to everyone equally. And this will be very important in an issue that is going to this. In a republic, there is protection of rights. The government protects the rights of citizens. Another feature of a republic is the absence of a monarchy. A monarchy is where leadership is hereditary and families. There is also equality of rights. All citizens have equal rights. Those are some of the characteristics of a republic. Uganda being a republic and having representative democracy and having a constitution that protects the rights of the people. This court-martial is enjoined to follow the Constitution. So what does the Constitution say on the reference of constitutional questions to the court, to the Constitutional Court? I want to read Article 37, subsection 5, where any question as to the interpretation of this Constitution arises in any proceedings in a court of law other than appeal court martial. And I want to pause there and say this is not appeal court martial. This is a general court martial. So this section applies to this general court martial. The court may, if it is in the opinion that the question involves a substantial question of law, the court shall give any party to the proceedings requested to do so, refer the question to the Constitutional Court for the decision in accordance with Clause 1. So you can refer the matter of your own accord. But when it is requested by a party, the way now we are requesting you on behalf of these two gentlemen, Dr. Besigye and Mr. Rutali, you have no leeway. You are commanded by the Constitution to refer the matter to a Constitutional Court. The matter, as my colleagues have advanced, arose in the course of your ruling, Mr. Chairman. And I will not go to the questions they have already framed. I will go straight away to a different question, the question of freedom from discrimination. in line with Article 21 of the Uganda Constitution. When there is no law to define who in Uganda chooses to bring civilians like Dr. Besigye and Mr. Rutare to the General Court Martial instead of the courts of judicature, that subjects them to discrimination, and it is our prayer that this question be added, whether it is discriminatory to bring civilians to a general court martial instead of a court of judicature, especially without a defined authority that makes that choice. Because the question we are asking, who made the choice? We do not know. The charge sheet does not tell us. There is no gazette notice to tell us that XY is the one who made. We can only guess that authorities within the military decided. But it's an authority we cannot touch. It's an authority we do not know. And in a democracy, discretion and power is limited by the Constitution and laws. There is nothing in this Constitution prescribing how, who and how the decision to bring civilians to a court martial is made. Therefore, when they are brought at the whims of people we do not know, authorities not defined, it becomes discriminatory. We want the court to answer whether indeed this is discriminatory as we state from the back. My colleagues have already argued that the fact that the offenses for which they are being tried are not defined is again something the Constitution abhors. And I've already said the Constitution exists to limit exercise of power. So if exercise of power is not limited by the Constitution, then it is unconstitutional. And the Constitutional Court needs to answer that question. I also want to add one more article of the Constitution, that Article 79 of this Constitution of Uganda, which mandates Parliament to make laws. It defines the functions of Parliament, and it says that subject to the provisions of this Constitution, Parliament shall have power to make laws on any matter for the peace, order, development, and good governance of Uganda. Except as provided in this Constitution, no person or body other than Parliament shall have the power to make provisions having the force of law in Uganda, except under authority conferred by an act of Parliament. And then finally, Parliament shall protect this Constitution and promote democratic governance. So the exercise of power to cause civilians to come to a general court martial are not defined in any law, and therefore they are unconstitutional and against Article 79. And we are asking you in framing that question, whether we can have exercise of power without, or discretion without limit, is unconstitutional, and Article 79 to that request. Finally, everybody, including yourselves, is obliged under the Constitution of Uganda to obey it. So we are urging you to stand up for the Constitution and to refer these questions to the Constitutional Court so that we can have finality. It may be something they argue that because others have taken the questions to the court, to the Constitutional Court, they have already been answered. I want this General Court Martial to note we have raised questions that have not been raised before. There are some that may be similar to those that have been raised earlier. Questions of discrimination, questions of a lawyer who is part of the team being arrested and detained and therefore not available, questions of fair process. There are various, quite a number of questions that have not been answered before. Also the fact that there is nothing in the Constitution that gives the UPDF judicial authority over civilians. And therefore, any act of parliament conferring judicial authority on civilians to the General Court Martial is unconstitutional. So it's a question the court will have to determine, to declare the UPDF Act unconstitutional to the extent that it confers judicial authority on civilians to the UPDF. And Mr. Chairman, when you are reading your ruling, you actually found that it was not, you alluded that it was not unconstitutional. The authority to interpret the Constitution is exclusively to the Court of Appeal, sitting as a constitutional court. So it will be useful even to you and the General Court Martial to hear an authoritative interpretation from the Constitutional Court as to whether you indeed can try any civilian in Uganda. The issue of extradition from Kenya, not extrajudicial rendition, not extradition. Extradition connotes a court process where orders are made. In this case, there was no court order. We urge that those issues are more than enough, and I'm asked by my colleagues that since we have exhausted, we end it here to give the prosecutor the chance to make a rejoinder.
Chairman and all board members, before we put in our agenda, we wanted to have a copy of the ruling which you made. Because why you are persons will not take a view was that some issues arose out of that ruling and therefore they need to be interpreted. And we also request that you provide us the case of Andrew Karmachi. So we don't have it. That's all. Yeah, you can give all the sources that you recited, but there are some which you haven't there. Then we also wait for 30 minutes the concerns.
Ladies and gentlemen, the court is adjourned for 30 minutes. Give time to state the rules. Submission of the resolution.
Guys, the issue koti bajiongezalo for 30 minutes. The court has been adjourned for 30 minutes. Yes. As states. The issue has been adjourned for 30 minutes. So all you need to do is to subscribe, like, comment, and share the link. If it's your first time here, you're watching Extreme Media UK. Professor Nicholas, aka subscribe, like, commenting. Extreme Media. Alright, subscribing, liking, atera, commenting. Tulina okumanya embeera bwetovugira yamani tuli mu kooti era kooti bagyongezaayo for 30 minutes. It has been adjourned. Courts have been adjourned for 30 minutes. What do you think happened? What do you think? Olowooza ki ekinaabirawo? Yesterday bagyongezaayo emirundi gyabali giweramuko naye kati leero bagyongezaayo once mirundi. The court have been adjourned for 30 minutes. Thank you for watching Extreme Media UK. All I need to tell you is that bapuliida ba Besigye bali mu kukola kyamaanyi nnyo. They are doing a big work, a big role. They are playing a big role. I'm telling you, they are trying their level best. Kuba nti ekintu kyo bakikola kitegedde ekintu kyo bakitereeza kubanga babadde babagambye okutuuka wano, babadde babagambye nti tugende mu maaso tutandike we twakomye. Bo ne bagamba nedda, we have issues. Kitegeera tetusobola kukkiriza bukkiriza nti amazima tugende mu maaso. So ngempenda owonsayo awo mu comment section and tell me where you're watching in from so that nkuboonako waleero mu magezi ekitiibwa tutambule tugende mu maaso mpola mpola. Otherwise you're watching Extreme Media UK. Nzisitedde ki ekiriwo? Aya basi embeera wetu bweri waneeno ku kooti. You are watching Extreme Media UK and Professor Nicholas aka John Paul UK is my name. Nsa atatya amagye sitya kooti kuba eno tesangikasangika bantu olina omanya eno. Don't think that everyone, every blogger nti natuukayo, nti every YouTuber natuukayo. Kitegedde ekintu ekyo. Ebintu sometimes bituuka nga kyetaagisaamu professionalism era n'amagezi agatuukayo. Otherwise you're watching Extreme Media UK. Subscribe if it's your first time here. Like, comment and share the link. Ate kyensobola okugamba kinso nti omukulu Dr. Besigye obanga wakatujoininga waneno ku Extreme Media. Dr. Besigye babawako kooti esabye newongezaayo for 30 minutes. So after 30 minutes bagenda kuba nga bakomawo. You understand? Subscribing, liking, atera, commenting, ongera okuddukiza nti Extreme Media UK gy'oliko era amazima okugamba nti byonna bijja kuba tukusaako waneeno oli Extreme Media. Kale kasomeko komenti zammwe waneeno mpola mpola as we wait for the court. Kimonge, we are stronger together. Never surrender. Thank you so much, Kimonge, for keeping it extreme media. This is Nambozo Shamim. Yeah, Nambozo Shamim since yesterday. Wabadde coach akabi kolo mulimu gw'amaanyi. Victor tulyazayo. Mami Samuel, I don't blame you. Oh, these are the problems. All right. Nkona kuwa ne take out a message. Nange nkona ko tulinda koti kwanga ekomawo. Subscribing, liking, commenting, gende mu maaso mpola bulungi aliko muliko bantu batimanya temulayikinga video muliko bangi lwaki temulayikinga mwena video. You like the video kuba mutima mubi. Yeah, there are very many here. Why don't you like? 138, only 38 have liked the video. It's going to be good. So liking out again. Thank you so much for the likes. Like says was making a video no kubanga etambula live no kubanga etambula tutegeera. Yeah man. So mbayite sharing a link. Endowooza yo compensation awo tulabe engeri gyetulina okubanga tukwasaganya kiri kyabaganda kansogere munzijukira omusajja wange yawa anze mbeerawo yesi alina abaddewo yabaddewo abali kukolamu ebitiibwa akuyisa erinnya neŋŋamba
nendimenyekeramu wadde okwera bulinnyo
okimanyi most times nze amanyi naliko bounce ati ng'omuntu bino bakumwejanzi bakwogerako erinnya amazima oba tolina masiki oba owedde
naye nze muli mpulira ndabye nga wali kisasa
ekiganda
kimenyekawo
manyi singa samweri nze ndi mukugamba singa samweri nze ndi mukugamba
sikisuubira
ate samutakanga bulungi etumye takanga agukanga mumanyi kategedde ani kankole guys oyo mbadde nyumyako ne afande wange wanene omubitiibwa afande twazirunda twazirunda so mbeera bwetyo eri wanene koti kirina okukola oyo afande twakubanga naye ekyuma gwe mbadde nyumya naye afande twakubanga naye ekyuma oyo abadde awo ku mulyango so guys subscribe, like, comment and share the video. Koti wajiongeza hiyo 30 minutes. Chukena wewe. Afande, kansubira nikoma wote muda wote. Sibina kutawali tu. Nenda kufuna kuchakulia. No, nenda. Afande, nimekufunda kwa nchakulia. Ndowooza it's okay. So my people. Njale numa walai. Mana kuliko ebyange.
Denyanjura.
Bade manyi kuliko ebyange. Ange. Bakukunya ekibuuzo. nina muno ssente oba ndi mukwetwala eno banange sirinaamu ssente badde nfulumyemu nga ndowooza ninamu ssente naye sirina.
Ono muteeke ng'alina ebyuma bye
Badde manyi ninamu ssente naye sirinaamu za kulya. Badde nfulumyemu nga manyi ninamu. Afande nakafuluma taata. Oyimirira amazima oyimirira n'okwowaaga wala. Kakirira ekagwababa oba kaba kawedde akasimu osanga kabeera buli kimu kakola. Oza nsobola ogipoozinga nsobola nagipoozinga soke ngiteeke wano. Kujjako nga yenze enyenyeri. Si tape yenu. Yes, please. Alright. Banange bagamba oba tuli mutegeera kigenda mu maaso kooti bagenzezaayo for 30 minutes. Akyogera batya? I'm not a lawyer. The court has been adjourned for 30 minutes. That word adjourned. Nina bu. Hani öyan. nedda tekisoboka kubanga yawezezza okujjako nga baguze subscribers. I'm telling you, subscription eyo bagiguze buguzi. Igwe oba they just recovered their YouTube channel eri eyabula kuba nayo yali mu 6K. Okimanyi ekyo? Iriya eno channel naye nedda oba baguze subscription kubanga erina 84 videos. Is that the recent one? Gye baali bakagulawo really? So banani my people nansonyiwa naye ekiriwo kyekyo ategedde akantu ako. Ebiki? Nobeera n'obukamera ng'obwo nga bubwo bwonna. The court have been adjourned for 30 minutes. guys, tuli ku extreme media yugi because nzemu ekigali tuli mukulaba kigenda mu maaso kooti yogengezaayo court in adjourned for 30 minutes. Kimanyi twakatambulako zizo zitegeeza we are almost coming back. But subscribe if it's your first time here. Subscribe, please. And when you subscribe, make sure you click the notification bell so that you'll be updated on whatever we upload here on Extreme Media UG. You're watching Extreme Media UG. Subscribing, liking, commenting. Yes, you are watching Extreme Media UG. It doesn't cost anything for you lose money. Sometimes what you have for 30 minutes. After 30 minutes, you end up with more one. So, kuweereza kulabe ekigenda mu maaso tubirayo amakinge kooti maaso omantegeeza kooti y'amagye muwa ku masannyalaze kirabika
Story maker so far.
Ale. Should be Mutino Nakawa, John Navy. I'm going to be in Seka. The second one. Bannange balina okuba nga mwekuumidde olw'omusango nange mwagala okuwulira mwagadde okuwulira mpulira entekerereza mulaze nti bani Dr. Besigye mulaze omukwano yani mulaze omukwano otherwise bwobanga gwe mulundi gwe ogusooka katuli oyinga kati busabe subscribinga clicking the notification bell onyigemu all ojja kuba updated ku buli kimu kye tuteekayo osobola nokujeninga awo munemba nojeninga nofuka nemba
Gracias.